What's happening in this context is very Orwellian. It's Big Brother, the state, saying, hey, if you don't agree 100% with our sexual orthodoxy, you're a heretic and you need to be silenced and suppressed. And really, they bully you, ironically. In the name of ending harassment and bullying, they're really bullying and harassing a lot of religious folks. And I actually confronted an educator several years ago and I said, you're trying to protect the LGBTQ identifying students from bullying and harassment, but what about all the other kids who have a different worldview? How do you think they're feeling? Do they think they feel safe and welcome and accepted in public schools? A lot of them don't. It's a problem. It's a big problem that nobody's talking about.
You must be some kind of therapist?
Today, my guest is Dean Broyles. He is a constitutional attorney who serves as the president of the National Center for Law and Policy. He's an advocate for free speech, religious freedom, and parental rights with extensive experience involving sexual identity issues in the courts, culture, and public schools. Dean regularly files amicus briefs at the U.S. Supreme Court in landmark cases and has spearheaded the effort in California to protect religious teachers from aggressive gender identity training. Dean, welcome to the podcast. Thanks for joining us.
It's great to be with you, Stephanie.
So I had a recent episode, as you know, with Laura Powell talking about Mirabelli versus Bonta at the Supreme Court. And we're going to pick up where that conversation left off, talk about Mirabelli, as well as other issues affecting teachers, public schools, parental rights, the future of how we as a nation handle these issues. I think you wanted to give a summary of Mirabelli for those who might not have listened to that episode with Laura or might otherwise not know what's going on.
Sure. Yeah. It's great to be with you today. I just want to kind of back up, and I think everybody's heard about the Supreme Court ruling, but I want to lay some of the groundwork for the ruling and how it relates to both parental rights and teacher rights. So I want to kind of back up and talk about the underlying case. And it's been going on since late 2022, early 2023, and there's been a lot of litigation back and forth. And so it's a multi-year case, and it's only barely out of the district court right now. But it started in the Escondido Unified School District, which is North County, San Diego. I actually happen to live in Escondido, and I've been following the case very carefully, and I know the parties involved, and I actually know the attorneys involved, and they're a great group of people. But it started off really as two teachers objecting to what we'll call the gender secrets policy. And that's been a policy that's been promoted here in California through various legislations and interpretations and misinterpretations of legislation that basically says that the schools, public education, school districts and schools and teachers should not share a child's self-expressed gender identity at school unless they have the consent of the student, the minor child. So what that really has developed in is a lot of different policies and practices. One is the statement that teachers and educators don't have the ability to share with parents what's happening with their child as far as gender incongruence or gender dysphoria, unless, like I said, they had the student's consent. Also, it led to social transitioning starting to happen to school, with teachers instructed to use the student's self-selected pronouns, to use the student's self-selected alternative names that might not match their sex, biological sex, or the sex they're treated as at home. And so these policies have been kind of codified at local school districts and really pushed and promoted aggressively from the California Department of Education. And so these teachers just said, hey, they were Catholic Christian background. And they said, we don't feel comfortable keeping secrets from parents and concealing information from parents and lying to parents, especially when it comes to issues that deal with a child's health, safety, and welfare. And so they filed a lawsuit. Ultimately, the lawsuit grew and expanded as it was litigated over time, and it actually, a class action was developed about a year ago, and there was a class of parents that joined the lawsuit, a class of teachers that joined the lawsuit, all who for various reasons objected to the gender secrets policies and practices in public schools.
So that's the background behind how Mirabelli ended up at the Supreme Court. And it's my understanding that it's not settled, but that some sort of statement has been made that we looking on are finding encouraging. That's what I talked to Laura about last time. Can you summarize that? I'm not good at legal terminology. I never know how to put these things.
Yeah, absolutely. So the good news, I guess, and people who are concerned with the gender ideology agenda that's occurring nationwide and worldwide right now, is that the judge really came down on the side of parental rights very strongly. And in his underlying opinion, and the motion for summary judgment, where basically after litigating the case, both sides filed their evidence, and Judge Bonita is here in San Diego County in the U.S. District Court, ruled against the state of California. And I'll just read a critical sentence from his conclusion, or a couple sentences. He says, although parental involvement is essential to the healthy maturation of school children, California's public school system parental exclusion policies place a communication barrier between parents and teachers. Some parents who do not want such barriers may have the wherewithal to place their children in private schools or homeschool, or to move them to a different public school district. Families in the middle or lower socioeconomic circumstances have no such options. For these parents, the new policy appears to undermine their own constitutional rights, while it conflicts with the knowledgeable medical opinion. And I'll just say parenthetically, in that case, there were several expert witnesses who said when children are suffering or struggling or experiencing gender incongruence or gender dysphoria, in almost every instance, it's best to have the parents engaged and involved in the process and be consulting with the parents. So that was the testimony that was given that the court relied on for that. The judge went on to say the state defendants are, in essence, asking this court to limit and restrict a common sense and legally sound description by the United States Supreme Court of parental rights. That this court will not do. Although as previously stated, the state's desire to protect vulnerable children from harassment and discrimination is laudable, the parental exclusion policies create a trifecta of harm. They harm the child, who needs parental guidance and possibly mental health intervention to determine if the incongruence is organic or whether it is the result of bullying, peer pressure, or fleeting impulse. They harm the parents by depriving them of the long recognized 14th Amendment right to care and make health decisions for their children, and by substantially burdening many parents' First Amendment rights to train their children in their sincerely held religious beliefs. And finally, they harm teachers who are compelled to violate the sincerely held beliefs of the parents by forcing them to conceal information they feel is critical for the welfare of the students. And that was signed on December 22nd, 2025 by Judge Bonita. And I was in the hearing that was, both sides argued for over 8 hours on both sides of that issue. And then what happened is that, as Ms. Powell confirmed last week or in your previous podcast, it went to the Ninth Circuit, and the Ninth Circuit granted a temporary stay of a permanent statewide injunction. So Benitez took that ruling and turned it into a permanent statewide injunction. And what happened was the Ninth Circuit went ahead and stayed it, and it was not a good opinion. It was just a very negative, cursory opinion. And I was predicting after I read it that it was going to be overturned very quickly by the U.S. Supreme Court. And I was surprised how quickly it was overturned. The Supreme Court on March 2nd overturned the Ninth Circuit's temporary stay and reinstated the permanent statewide injunction as to the gender secrets policies as to under the parental rights analysis. They didn't make a firm decision on the teacher rights involved, but they did rule on parental rights. But in the ruling, the statewide injunction has some good language and good news for both teachers and parents that I'll share in a minute.
Well, what's the good news?
The district court issued a statewide injunction. Part of the language in that statewide injunction was language that they needed to include in any training they did of parents, any training they did of students or even teachers when it came to gender identity. And so the judge specifically wrote, Judge Bonita wrote, defendants shall include in a prominent place in PRISM training materials and in any other state approved or created instructions on the gender-related rights of students and faculty the following statement. And this is a quoting from the language that's actually now on the California Department of Education's website and in the PRISM training and other trainings. It says, quote, parents and guardians have a federal constitutional right to be informed if their public school student expresses gender incongruence. So number one, parents have a right to be informed. And it goes on to say teachers and schools have a federal constitutional right to accurately inform the parent or guardian of their student when the student expresses gender incongruence. So teachers have a right to inform parents. Okay, so parents have a right to be informed and teachers have a right to, and schools have a right to inform them. And then here's a key quote. These federal constitutional rights are superior to any state or local laws, state or local regulations, or state or local policies to the contrary. And that gets to something that, we learned in first year constitutional law. It talks about the federal supremacy clause, that if there's a federal constitutional right or a federal statute in place, and that'll come into play with teacher rights in a minute, that actually supersedes any state right to the contrary. And that's important here because the state of California had been arguing that their policy protected the safety of students and it protected the privacy of students. So the reason the state of California said it could keep secrets from parents is to protect the safety and privacy of students. And what the judge was saying there is no, parental rights protected by the First Amendment and by the 14th Amendment, which we'll talk about in a minute, those actually supersede state law and any privacy claims or other claims to the contrary.
Yeah, the really bizarre thing, and I talked about this with Laura as well, is that when it comes to the safety and privacy of students, that's being treated as if the parents are a threat to that rather
right.
than the people the absolutely most concerned with that. Now, you mentioned both parents and teachers having a right to be informed and to inform respectively. But this raises the question of what is the teacher's obligation? Because we have a broad variety of teachers in California. I'm sure as a conservative lawyer, you help teachers who might be looking for protection for their religious beliefs, which I think you have some expertise there to fill us in on. But then, of course, we also have teachers who've drank the Kool-Aid, who maybe see themselves, as I discussed with Laura, as having some sort of well, they wouldn't see themselves as having a savior complex. That's how I would label it from the outside, but they see themselves as a sort of righteous rescuer of this poor, oppressed trans child from their bigoted parents. And if that is their sincerely held belief, as much as you and I might disagree with it, what do we know and what do we not know at this point in time about a teacher's obligation to inform the parents rather than just the right of teachers who choose to inform the parents?
Yeah, so the court hasn't yet said that in every instance the parents have to be informed by a specific teacher. But if we kind of jump to the Supreme Court ruling, the Supreme Court, both in the per curiam opinion that was issued on March 2nd and in the concurrence and even in the dissent, they acknowledged that parents had rights to know. And so, and that's it's a healthcare issue, right? It's a mental health issue, right? So it would kind of follow logically that if it really is a mental health issue and parents have right to know that somebody who knows has a position of knowledge and authority in loco parentis in public schools, that they would need at some point have an obligation to tell the parents. The courts haven't really come out and said that yet, But it's kind of, I think, where the case is going, because if it is a mental health issue and the parents have the right to know, whether the parents affirm or don't affirm the child's identity, right? They're the ones who love the child, know the child best, and are most likely to get them mental health care when they need it, right? And so, if parents have a right to know and schools know, then it's probably going to become an issue at some point that somebody has an obligation to tell them, whether it's an administrator or a counselor at the school or a teacher. The court has not ruled yet that individual teachers have to tell parents if they know. But there is a broader statement that the school can't conceal it either. So where this has really come up is in school records, right? So what schools in California have done is they've got these shadow records, these second set of records from the official records. The official records of the student would have their name and biological sex that they're registered as by their parents. But the shadow records, or the second file, would be a file that would have the student's gender identity and their personal pronouns and what bathrooms they want to use and those types of things in the file. And those files have been kept from parents intentionally by school districts. And I've heard about and seen copies of these files, and it's pretty outrageous. But what kind of getting to what you were saying earlier, that whole system assumes that all parents or most of the parents are unfit, right? That you're automatically unfit if you don't automatically affirm. And so and it assumes that the state knows better, and the state being, teachers or school guidance counselors know better than the parents do, right? And so it's basically, stealing or stealing parental rights away from parents and giving them to the state, when the state doesn't necessarily love your child, the state doesn't necessarily know your child, the state doesn't necessarily have your child's best interest in mind. They may have an ideological agenda that conflicts with your parental rights and your family's religious beliefs. So it's very disquieting and unsettling to think in a democratic republic that we would have any system in place that assumes parents are unfit automatically and starts concealing information from them and starts socially transitioning a child in a very touch and go, issue for counseling and psychiatrists, which is gender dysphoria or gender incongruence.
Let's talk about those shadow files. So I know of forms that students are asked to fill out with their personal information and, to check a box saying whether or not you want the teacher to refer to you by the same pronouns when they're talking to your parents as when they're calling your name in class. Um, is that the extent of it, or is there more to these shadow files?
Yeah, there can be more. I mean, sometimes they're thin and they just have, check the box for name, check the box for pronoun, check the box for bathroom or sports teams or things of that nature. But often, what will happen is, teachers and the guidance counselor, maybe administrators, will come together and they'll create what's called a gender support plan, right? Where it's not just the student saying, this is what I want, please oblige me. It's the school kind of cooperating with that student to socially transition them behind their parents' backs. And so it's a little bit more nefarious and involved. And sometimes the school guidance counselors and teachers are pushing the child in that direction and cheerleading the child in a way without looking at their potentially other underlying mental health problems that could be involved. So it's very problematic.
You would think, if everyone were operating from common sense, that the teachers, administrators, counselors would have some sense of what all else was going on with that kid that might have led to the gender identity issue. I mean, we've heard many stories of a kid getting bullied until they came out as trans and then being popular or at least protected. We've seen many instances of things like that where you would think any adults in the kid's life at school would see that and have their heckles go up in the same way that my heckles went up as a therapist when I was seeing kids claiming to be trans after knowing what else they'd been through in their lives, right? It was seeing that, putting the pieces together that got me questioning the whole thing. But unfortunately, I think we do know that, even when okay, let's take a situation where there is a known abusive parent and that has already been dealt with legally, and that person has lost custody. Let's say the boy's with mom because dad's in jail, okay? Like, even in a situation like that, right, where everyone at school knows about what happened to his dad, where common sense would go, "Oh, this boy doesn't wanna be like his dad? Of course he doesn't wanna be like his dad." You know? Do you think that might have anything to do with him saying he's a girl? You know? But we're not seeing that common sense in teachers and counselors. We're seeing common sense go out the window when gender identity enters the picture.
And that's the unfortunate price of locking parents out of the conversation, right? You don't have the history and the background and information that may be helpful to explain what's happening, and that it's, I mean, I'm not an expert on social contagion and social movements, but I know that a lot of people are starting to look at this spike that occurred in the last decade or so with trans identifying students as it became like a popular thing to be and do and say you were, and there's a lot of peer pressure in that direction, and so not just from fellow students, but teachers and administrators and in popular culture, and so you know I'm not saying that there aren't people who really genuinely struggle with gender incongruence or gender dysphoria, but I think the numbers are much lower if you remove other factors and treat other underlying issues than people think they are.
So tell us about more the religious accommodation angle.
Before I jump into that, I just want to talk about the Supreme Court ruling because it relates to that. It kind of sets the table for that. So let me not I won't beat a dead horse because I know you went over it already with another guest, but the Supreme Court's opinion was very important, not only because it's the Supreme Court, but because there are really important ideas that are expressed here. And so what the Supreme Court did is they didn't rule on everything that had been ruled upon in the local district court. What they did is they focused really on parental rights. But I'll talk about in a minute how those parental rights affect teacher rights. So basically, they were addressing the gender secrets policy and the names and pronouns issues that we've been talking about, and whether the district court got it right or whether the Ninth Circuit was right in reversing that permanent injunction. And essentially what the U.S. Supreme Court did is they said, no, the district court was right, particularly on the issue of parental rights. They didn't decide teacher rights, and that's important I'll talk about that in a minute. But what the Supreme Court did is they said, yeah, the parents win or are likely to prevail because this is a preliminary injunction standard. So when they rule in favor of someone, they say, what's the likelihood of success on the merits? And so because the case was coming up on an emergency basis, they were basically saying, if the case comes back to us, we think here's why they would most likely win. And so it's not a permanent decision on the merits, but this is a very detailed decision. And the court said parents are likely to win for two reasons. Number one is a First Amendment right I'll talk about, and number two is a 14th Amendment right. The First Amendment right goes back to a case that was decided last summer called Mahmoud versus Taylor. And in that case, Maryland had a policy and practice of reading LGBTQ themed storybooks and having different exercises and instruction and sprinkled throughout the curriculum. And parents had asked for a right to be notified. Religious parents had asked for a right to be notified and be able to opt out of those lessons when they came up. And originally the school district said, yeah, we'll do that. We'll notify you and allow you to opt out. Well, they got so many opt-out requests that they actually shut it down and said, no, we're going to take away that now. That right, now that we gave it to you. And so they got sued and went to the Supreme Court. And Supreme Court said that parents have a First Amendment religious free exercise right to instill religion in their children, to pass on their faith to the next generation. And the case they relied on was a case from 1973 involving the Amish. And back in 1973, in a case called Wisconsin versus Yoder, the Amish said, American high school is so culturally antithetical to our values as a community that we don't want our kids to go to public schools after the 8th grade. We don't want compulsory education for Amish children after the 8th grade. And you know what? The U.S. Supreme Court agreed with them. They said, yeah, the values undermined or taught in American high schools undermine your religious Amish faith. So we're going to allow you to take your kids out of school after 14, when they're in 8th grade, if you want to. And so what the court said in the Mahmoud case is when lessons are taught, not just LGBTQ lessons, but when lessons are taught that substantially interfere, undermine with the religious faith that a parent is trying to pass on to a child, that parents have a right to notify the school that they want to be told ahead of time that the lesson is occurring, number one. And number two, the right to be able to opt out from it. And the Supreme Court said, yes, will protect the religious beliefs of families by requiring notification opt-out. And this is really what the First Amendment requires. And so that was a big win, but it was a big win really only for religious parents in this area, right? There may be non-religious parents who object to gender identity ideology and might want to be notified and opt out of that, for example. So that the reason I give you that background is because now the Supreme Court in Mirabelli said, no, we're not just ruling in favor of religious parents and the right to pass on their faith. We're actually ruling under the 14th Amendment that all parents have a right to opt out of this or be excused from this kind of activity. And what they said is that parents have a right under the 14th Amendment to direct the care and education of their children, right? So those are cases dating back to 100 years ago involving, whether parents could send their kids to Catholic schools, like an old case from 1923 called Pierce versus Society of Sisters. And fast forwarding to today, there's been other Supreme Court cases that have said the parental right to direct the care and education of your children extends to healthcare decisions, and it also extends to mental health care decisions in a case called Parham. And so the court in Mirabelli said, in addition to the religious parents having religious objections, non-religious parents or any parent can have an objection to these materials and can ask to not be a part of this. And what the court said is parents, not the state, have the primary authority to with respect to the upbringing and education of children. The right protected by these precedents includes the right not to be shut out of participation in decisions regarding their children's mental health. And so the court also said that California's gender secrets policies likely violate the parental rights to direct the healthcare and mental health decisions of their children, right? So that makes sense also. So there's a religious right under the First Amendment of parents. There's the what we'll call the secular right under the 14th Amendment of parents to make decisions about their healthcare. So that is a real strong affirmation by the U.S. Supreme Court that parents, not the state, should be the primary ones making these decisions and not having their religious beliefs or choices undermined by secrets.
It seems like really good news in theory, and then in practice, I wonder how it works. When you think about how baked in the DEI stuff is to curriculum, I mean, it's one thing to know that your kid is in a health class, which has a unit at precisely 6 weeks into the first semester of 7th grade where they talk about this and that, and you ask to review the curriculum, and then you decide to excuse your kid from that class, like, that's one thing when it's compartmentalized like that. But I think in real life, it seems like the lines aren't so neatly drawn. What are your thoughts on that?
A lot of parents, are afraid to opt their kids out because, they don't want to be seen as those parents, right? Or they don't want their kid to be ostracized or bullied, and so there's that issue. Some parents are afraid to opt their kids out, even if they can. What we developed, and we'll be talking about this, at a statewide webinar coming up next month on parental rights and teacher rights, is what organizations like ours are encouraging parents to do is understand generally what's in the curriculum, figure out what their religious beliefs are, if it's a religious parent, for example, and communicate at the beginning of the school year, hey, here are my sincerely held religious beliefs. Here are my here are things in the curriculum that you may be teaching that will conflict with them, and I want to be notified and have the right to opt out. And that kind of puts the burden then after Mahmoud on the district to notify parents when they teach things that they know are going to be on the parents' checklist. And some parents could have very short checklists. It could be just LGBTQ stuff. It could be, some people are offended by evolution being taught as a scientific fact versus a scientific theory, things of that nature. But, parents might be object to witchcraft being taught as cool and things of that nature. So it's not just LGBTQ issues that parents can opt out of. It's other things too. And so we're developing resources where parents can identify their beliefs and objections and ask to be opt out. And by law now, after Mahmoud, the school has to honor their rights. Unless the school somehow can successfully argue, which would be hard for them to do, that it doesn't substantially burden the rights of parents to pass on their faith to their child, which is going to be something the school doesn't want to get into. But you're right. Practically, will a lot of parents use that right? I'm hoping they do, because that's one of the problems, I think, in public education today, and why so many people are fleeing public education, is it's become much more ideological, not just on transgender issues, but on a number of issues, and not respecting the rights of different communities and different religious groups who are undermined and offended by what's being taught. And so I think if we're going to public school, as much as possible, needs to be neutral and not be going around throwing elbows and defending people. And I think public education can do a better job of that. And I'm hoping that enough parents start opting out so it kind of cleans up things to where we're back to teaching reading, writing, math, and science rather than ideologies that not everybody agrees with.
In practice, if a parent goes through those steps and notifies the school, here are my objections to certain types of content, and then they find out that their wishes have not been honored, what recourse do they have? What steps can they take? Is there can they file a complaint? Who's accountable?
So good question. They do have legal rights, and it's not necessarily to get money damages if their rights are violated. Typically, these cases involve mostly what we call injunctive and declaratory relief. We handled a case in Encinitas, for example, where the district not only taught gender ideology, but had these Catholic Christian students participate in the mentoring of kindergartners in gender ideology. It was very coercive stuff. And, we filed a lawsuit and we're prevailing in that. But typically what you would get is an injunctive relief, like happened in Mirabelli, where the court says, stop doing this, right? Knock it off. So in our case, in Encinitas, the district adopted a policy pursuant to Mahmoud that says we're going to notify parents and allow you to opt out now, which is all the parents were asking for all along. They said, hey, we're not telling you can't teach this stuff, even though we have ideological differences with you. What we are telling you is just let us know and allow us to opt out to protect our kid and their conscience if you do it. And the district said, no, the district was brazen. They said, we're going to keep teaching it. We're not going to tell you when we're teaching it, and we're not going to allow you to opt out, be notified or opt out. So that's very, in my mind, that's un-American. That's very anti-parent. It's anti-family. It's anti-religion. It's not what we're supposed to be about here in the United States. So
Another place where I can see this running into some problems in the execution is how schools handle student gender transitions when let's say that a school is in compliance. So let's say that a school is honoring the parent's right to be notified, and the school and parent are in communication. And let's say you have some affirming parents in a school who think it's great that their kid uses some other name and pronouns and is getting on board this medical conveyor belt. And those are their sincerely held beliefs that this is a good thing, right? And those students with those gender identities that are supported and encouraged by their parents, where the parents and the school are communicating, are sharing a classroom with students from conservative or religious households, or simply who do not believe in gender identity ideology. So there's a question of how the students are asked to speak about their classmate, that they're asked to use the name and pronouns, and furthermore, that this is discussed under the umbrella of anti-bullying. I'm trying to remember which experts I've had on this podcast to talk about how that's been that sort of sleight of hand that they've done with the anti-bullying stuff, and how they use that to slide a lot of gender identity ideology by people. So, practically speaking, when a student who, let's say, shares their parents' religious beliefs and doesn't believe in gender identity ideology is sharing a classroom with a student from a much different background, how, what the rules are in school in terms of, using preferred pronouns and everyone getting the lesson on why you need to respect people and why respect needs to take the form of lying about people's sex. Um,
always affirming, no matter what. Yeah.
I'm wondering how that plays out for students.
So that's a great question. And, there's a great case called Tinker versus Des Moines that dealt with high school students protesting the Vietnam War by wearing black armbands. And there's a great line from that case. It says that students do not shed their constitutional rights at the schoolhouse gate. Okay. So in that case, what I would argue, and I think we would prevail on it, especially with this Supreme Court, is that whether it's under the guise of anti-bullying or harassment, the state cannot coerce student speech, right? The state cannot tell that student you have to use a name that doesn't conform with gender or a pronoun that doesn't conform with their actual sex. Let me correct that. And so, yeah, that violates the conscience of that student to say things that they believe are untrue, right? You're telling them, for the sake of peace and anti-harassment, anti-bullying, basically you have to suppress your belief, right? And silence yourself and censor yourself for what's, what we'll call the LGBTQ greater good, right? And so that's problematic because at that point, the school is coercively trying to violate the free speech rights of in this case, a religious student who isn't on the transgender bandwagon. So we would sue the school for violating their First Amendment rights.
So that was a Supreme Court case back in the 70s?
It was the Tinker versus Des Moines, I believe, was the late 60s. Yeah, but it's been reaffirmed over and over again. So teachers' rights are a little bit more murky in public schools, but student rights are definitely well protected in public schools.
Your trans-identified kid won't listen to reason because reason isn't what they need right now. They need a parent who knows how to communicate in an empathic yet strategic manner. ROGD Repair gives you over 120 lessons in the psychology and communication tools that actually work when normal parenting doesn't. Plus, RepairBot, your 24/7 AI coach trained on my entire body of work, ready to help you navigate tough moments in real time. Visit rogdrepair.com and use code SOMETherapist2026 to take half off your first month. So tell us how this works in practice then. Given that the students' free speech rights are protected, that feels intuitively to me like it flies in the face of stories I've heard, although I can't conjure any particular story, but I feel like I've heard stories of students being called in the principal's office for their sincerely held beliefs. And I'm wondering, of course, there's always, regardless of law, regardless of policy, there's always social incentives and disincentives. And that's what students are going to base their behavior on most of the time. Most middle schoolers do not have strong faith in their convictions so much as they have a great deal of social anxiety and care for what the group thinks. And, even the boldest of sixth graders are not particularly wired to go against the grain and say unpopular things. But what I am hearing is that the protection is there, even if it doesn't feel like it in the culture of the learning environment. I'm just wondering how this plays out for a student. Let's say there's a parent listening who, take a recent friend of mine, met a woman recently who has a 15-year-old daughter, and she said, "My daughter is an even bigger turf than I am." So suppose that my new friend is listening or her daughter, maybe she's listening with her daughter, and the daughter wants to abstain from using preferred pronouns in a woke, Portland public school. What should that daughter and her mom know about her rights and how that plays out in practice?
Well, these cases are often fact sensitive, but I would say, you have to be brave and bold and courageous to stand up against the cultural wave that we've all been kind of under, especially on the transgender issue recently. But I love to represent people who they're not hateful, they're not mean, they're actually not bigoted. They actually love people no matter how they identify, but they're just not willing to lie. It's like Alexander Solzhenitsyn wrote that speech in that article on called "Live Not by Lies." We're just not willing to say things that aren't true and that aren't consistent with what they believe about human sexuality. And so they could, depending on the facts, we or an organization like ours would represent them if the school is pressuring them to say things or do things that conflict with their sincerely held religious beliefs. And so typically, and we do these cases all the time, we'd be making a religious free exercise claim on behalf of the student, but we'd also, in that context, be making a free speech claim because they're trying to coerce speech. And that's not just speech. by speech, they're trying to really coerce what they believe, right? What the student believes or what they're able to express about their own belief, right? So it's very, what's happening in this context is very Orwellian. I mean, it's Big Brother, the state, saying, hey, if you don't agree 100% with our sexual orthodoxy, you're a heretic and you need to be silenced and suppressed. And really, they bully you, ironically, in the name of ending harassment and bullying. They're really bullying and harassing a lot of religious folks. I mean, even here in liberal California, approximately 70% of the public is representing a different religious beliefs, right? And so, and a high percentage of those probably have fairly traditional religious beliefs, and a lot of them go to public schools, and they're feeling bullied and harassed and silenced. And I actually confronted an educator several years ago, and I said, I know you're trying to protect the LGBTQ identifying students from bullying and harassment, but what about all the other kids who have a different worldview? How do you think they're feeling? Do they think they feel safe and welcome and accepted in public schools? A lot of them don't. So it's a problem. It's a big problem that nobody's talking about.
So you're talking about the chilling effect on the student, not only what they feel that they can say, but what they can believe, because so much of how we arrive at our beliefs is through talking to other people. And that makes me think of a third factor, which is what students signal to other students are acceptable thoughts to entertain. I suspect that there's a lot of preference falsification going on, especially in uh, blue states, because I know, and I've talked on this podcast and I've talked behind the scenes to many people in traditionally liberal areas, many of them still quite liberal themselves personally, but who do not agree with gender identity ideology. And it's really frightening how hard it is for people to even find each other, to find other people in their own community who share their beliefs, or who otherwise have not bought in to this crazy set of beliefs. So if students feel, I mean, we're talking about two different things, because we're saying legally students do have free speech rights. No student in a public school can be compelled to use speech that feels like it violates their sincerely held beliefs, whether those are religious beliefs or simply beliefs in biological reality. But practically, the culture of the school is a different matter. And when it comes to the culture of the school, that's what I'm concerned about is, can students find other students who are questioning this? I mean, how many times have any of us looked around for someone else in the same room to validate our perspective when it's something didn't seem right or smell right, or something is off? You hear something. Do you hear that? Is that my tinnitus, or is there a high pitched sound in the room? You look to other people to see, am I crazy? Am I being hypersensitive, or is there something going on here? And students in a developmental time in their life, if they can't do that with each other, if they can't, say, "That's a boy, right? That's a boy." If they can't do that, then they're just constantly being gaslit and their natural instincts are being suppressed. And then you end up with this broad scale preference falsification where it's like the emperor's new clothes. Everyone thinks that everyone else really sees the clothes, and most people don't.
Yeah, it's interesting to use the term emperor's new clothes because when I've written about years ago, I was writing about what I called the gender blender and gender confusion. And before it was even, right after it was pushed at the US, after the Supreme Court ruled on behalf of same-sex marriage, right in 2015, as soon as that constitutional right was recognized, that's when gender started being pushed right away. And I predicted then that that the T was going to unfortunately boomerang on the whole movement. And it's unfortunately happened. I mean, T is now fallen quickly out of favor because of things like the Cass report from England, the HHS report recently last year, and the scientific research is starting to really come out against the idea of pushing kids in this one way direction. It's very harmful. But I use the same term. The emperor has no clothes. Why? And I felt like I was alone in saying that out loud, 5 to 7 years ago. But now it's becoming more popular. And I think for me, the issue of gender ideology, until people realize how people are being harmed by it, right? Like lobotomies, it used to be popular with people with mental problems to do lobotomies. And thankfully, we don't do that anymore because it's unthinkable, right? I think we need to make butchering children's bodies with chemicals and hormones and surgeries unthinkable, because it really is causing a lot of harm. But the whole idea of peer pressure kind of maybe is a good segue to talk about teachers, right? Because it's not only students in the classroom being pressured to use pronouns and names, it's teachers, right? And they've got the Damocles sword hanging over them of maybe losing their job if they're not with the program. And so what's happened is really, in my mind, almost diabolical here in California. There was a law that was passed in 2023. It was called AB5. And the idea of AB5 is, hey, we've been pushing this agenda for a decade now. We've been passing laws, and the CDE has been pushing the lie that legally schools had to keep gender secrets from parents, right? And so everybody is kind of, they thought they had everybody bought into it, but they're like, oh, we need to make sure all of our teachers are on board. So they created what's called LGBTQ cultural competency training in 2023. And there's about 10 to 12 things that the statute says, oh, when you go through the training, this is what you need to teach. And it's a 5-year, 1 hour a year training. And the California Department of Education was tasked to create this model training. It's called PRISM training. And they started implementing it and putting it into practice this year. The first year of training was this year. And we started getting calls from all over the state, from Christian teachers and even teachers of other faiths, who said, this stuff is very coercive. It's very aggressive. I can't in good conscience even take the training, basically, is what these teachers were starting to say. And we started looking into it, and basically the training, among other things, said you're basically a bigot on the wrong side of history if you don't affirm, right? And affirm, I'm not just talking about, all the LGBTQ stuff, but they're really focused on gender in the training. If you don't affirm the child's chosen name, pronouns, and keep secrets from parents, and you don't create a safe space in your class with all the LGBTQ banners and stuff, then you're not a good ally, you're not a good teacher, and you're not culturally competent. So it's trying to push all the teachers, no matter what their sincerely held religious beliefs are, to affirm. And essentially, it's so coercive. It basically tells these teachers, you need to suppress what you believe, and self-censor yourself. And if you don't, it's the best way to describe it is it's basically asking people with a worldview of human sexuality that's traditional, biblical, Christian, Catholic, etc., to basically erase and replace their worldview. It's like, here's the right belief, here's a wrong belief, you're believing wrong, believe this and do this and say this, right? So it's very, and it tells them, here's what you need to do in the classroom. And so we got involved, and I did a lot of work on religious accommodation. I'm actually an expert in religious accommodation. I've done a lot of cases, especially during the pandemic. And I'm actually been asked, I'm a constitutional attorney primarily, but I do a lot of religious accommodation employment cases, and I've had a lot of success in that. So when teachers started reaching out with the concerns, nobody else stepped up to help them. I thought somebody needs to help these teachers because they should even have to be subjected to this very aggressive, coercive, Orwellian training. And so we developed a religious accommodation request letter that actually, argues that these policies and practices that were pushed by PRISM, and they're the same policies and practices we've been talking about all day today, violate the First Amendment rights of teachers to be free from coerced speech themselves, like the students we were talking about earlier, and also it violates their free exercise of religion. But the main leverage we have is actually statutorily under Title VII, federal Title VII, and similar state law called the Fair Employment and Housing Act. Basically, what those statutes require is that an employer must accommodate the sincerely held religious objections to an employer mandate in the workplace unless it imposes an undue hardship on the employer. And undue hardship was recently ruled in favor of employees at the Supreme Court recently. The standard was set back in a case a couple of years ago called Groff versus DeJoy. And so we started telling these teachers, hey, guess what? You have a right to request religious accommodation, and they have to accommodate you. And they really don't have a defense that it imposes an undue hardship on the school, because undue hardship is a significant burden or expense, and the school just can't meet that defensive test. And so we started writing these letters and started submitting them in November. And over time, school districts have actually pulled back on PRISM. PRISM was created by the California Department of Education. They subcontracted with the Los Angeles County Department of Education, who brought in a coalition of very far left groups like the Trevor Project, ACL Youth, Southern California, Advocates for Youth that does cartoon pornography for kids in schools. I mean, just all these really woke groups who are really pushing the trans agenda in a very radical way in all spheres of their influence to create this curriculum. And I said earlier, there was 10 to 12 kind of more vanilla type things that the training was supposed to include. On a scale of 1 to 10, I would describe the statutory requirements in the training maybe about a 5 of being bad as far as ideology. But what they did is they supercharged it in the form of this PRISM training, which was the model for everything else. That was probably a 10 or 11 on a scale of 1 to 10 of being really ideological and aggressive. And so these teachers saw this training and are like, we can't do it. We can't take the training. And so we developed this resource and started pushing back. And thankfully, some districts have created alternative training that's a little bit more watered down, not as aggressive, but it still statutorily has to be similar, substantially similar to PRISM. So all the training is bad. It's just the question of how bad is it? How coercive is it? And recently, since the Mirabelli decision at the U.S. Supreme Court, all of our clients have been getting not just offered alternative training that's still bad, they're now being told they don't even have to take the training at all. Not just for this year, but some of them for all 5 years. And so in the context of protecting teachers' rights, we're being able to do that successfully. What's sad to me, though, is that kind of fear factor that we talked about amongst students. It's very prominent amongst teachers, too. Teachers don't want to be looked down as, homophobic or, transphobic bigots or whatever. So they're afraid to reach out and make a stand. And some of the teachers have kind of bit the bullet and gone through the training anyway, but then come back to other Christian and Catholic teachers and said, in tears, and said, I really feel like I sold my soul. I really feel like I violated my conscience to take this training, and I wish I hadn't done it. And so even though we're helping hundreds of teachers across the state, in a state the size of California, we should be getting thousands, if not tens of thousands of assistance requests, and we're only getting a few, in part because, as we've been talking about, we live kind of in a post-Christian culture, in a post-truth culture, and a post-traditional culture, where if you maintain a biblical view or a Christian view or a Catholic view on human sexuality, you're seen as backwards and kind of cast aside. So even though, like we said, you're legally protected, a lot of people are afraid to stand up. And the problem is, whether you're a Christian or not, if you can't stand up and speak the truth and speak it boldly and clearly, we don't live in a free nation anymore. And there's this kind of sociological theory that was developed after pre-World War II Nazi Germany to explain why did so many Germans go along with what Hitler and the Nazis did, right? Not just to the Jews, but to everyone. And the idea is, as more pressure comes against truth, the more people wanting to save their skins and their livelihood and their families, they become more and more quiet and silent, and it's called the spiral of silence. But that spiral can be reversed. And I think we're seeing that happen in this transgender space, right? Where more people are willing to speak the truth of love and speak up and say, this is insanity. We've got to rethink this. We're seeing more of a movement against it. And we're making, I think it's starting to become unthinkable. And so I'm hopeful that the truth will prevail, whether from a Christian perspective or from a secular perspective in this whole ideology. I just wanted to affirm that teachers and students have rights. It's not, even though we were focused on parental rights with Mirabelli and Mahmoud, it's actually spilling over into the teachers. And, one of the things that the court has said is that the teacher's right to inform parents is their religious right too. That's what Judge Bonita said. If they believe, if their religion teaches them that parents should be the ones in control of their child's life and not the state, then the teacher actually has a legal constitutional right to inform parents. And that's kind of boosted by the parental right to know, right? The parental right to know that information. And so I think the rights of teachers and parents are very well intertwined and aligned here. And some teachers won't want to tell parents, but I think it's a mistake to assume that all parents are unfit, therefore all parents must be kept in the dark. I think that's a very dangerous proposition.
Are you a free-thinking therapist looking for like-minded community? The Association for Mental Health Professionals is a sanctuary for holistic, critical thinking counselors and therapists who want to stand firm in our values and reclaim our profession from ideologues. AMHP offers its members a blog and podcast, monthly webinars, and an annual conference each fall in Texas. Visit associationformentalhealthprofessionals.org to join a growing number of like-minded therapists who want our profession back. All right, now back to the show. We've been talking about this from the angle of teachers' rights to inform parents and parents' rights to be informed. I feel silly for not covering this earlier, but what does all of that have to do with policies on using preferred names and pronouns when parents don't approve? Because are parents in California essentially being informed, hey, your kid is going by this other name and pronoun in school, and if the parent objects to that, well, we checked the box, we informed you, and we're going to keep calling them what they want to be called in school? Or does it go beyond information? Do the parents have a right to decide if that name and pronoun can be used or not?
Yes. So Some of this needs to be worked out in the courts, exactly what the parameters are. But I think that's where it's going, because if parents have the right to direct the care and education of their child, and that includes knowing about the gender dysphoria. It's not just knowing about the gender dysphoria. It's kind of being in charge and where that goes, right? In other words, the state shouldn't be in charge of what happens with that. It's the parents who are in charge of what happens with that, and their mental health care providers, right? So I believe ultimately the courts are going to say, and the state's kind of interpreting it this way so far, is that, hey, if a parent tells you, tell me if my client is expressing gender incongruence, then we need to tell them, right? If the parent says, I don't want you to use preferred names or pronouns, then we probably need to respect that, because that seems to be where the Supreme Court is going with all of this, that the parents have a superior right to make those decisions over the state. So the state can't undermine not only the religious parental rights involved, but the healthcare parental rights that are involved for everyone, even if they're not religious. So I think that's where it's going, but we're still kind of early in the litigation. There's actually, besides the Mirabelli case, there's, I think, up to several dozen other cases, including the Foot case, that are pending before the Supreme Court or working their way up towards the Supreme Court. So I think the court, in the per curiam decision that they issued on March 2nd, was signaling that, hey, we're gonna side strongly with the parents on this issue, and you can't keep secrets anymore, especially if the parents tell you they want to know, and especially if they tell you not to socially transition the kid behind their back. And I think that's going to spill over and benefit teachers too, even though this current Supreme Court ruling didn't really address the teacher arguments. They were primarily addressed at the lower court level by Judge Bonita's. I think ultimately the arguments and facts that were provided there will also curry in favor of teachers who want to notify parents.
So it is moving in the direction of parents having the right to say, no, you may not call my child by a different name and pronoun in school. And that's not set in stone yet. It is being framed, however, at least by you here, as a healthcare decision, which I would agree with. And that is something I discussed with Laura Powell in our episode on this topic. She raised the question of, is social transition a medical intervention? And she and I both said, and I'm sure you agree, that it is, and therefore should not be made by people without a medical background or without a counseling background. But of course, I have my objections with the way that a lot of my colleagues think on this issue. And uh, part of the issue that I see is therapists wanting to see themselves as good people who are just following their client's lead, taking it one step at a time, exploring gender identity, and not acknowledging that, for one thing, as a professional and as an adult other than a child's parent, we have a certain degree of authority with our patients who are adolescents and young adults, and that authority means something, and that our stance, even if we think of it as exploratory, can be interpreted as a validation of the identity. And that things like going along with using names and pronouns are not neutral. And I cannot tell you how many stories I hear in my unique role as a coach for these parents of them finding a therapist they thought was well vetted, typically not someone with a high profile like myself. In fact, I specifically advise them not to do that. I say, if your child's therapist can be found on the transgender map website, then that's not going to work, because your kid's going to Google them and they're going to say, oh, this person's a terrible Nazi, right? So you want someone your child will trust and establish rapport with, but you also want to make sure that person's well vetted. I cannot tell you how many stories I hear of parents taking their kids to these people they think are going to explore the issue, not just take a declaration of identity at face value as some sort of demographic label. And then so much of the time, these therapists end up affirming the identity or, talking to the parents often in front of the child about the importance of just giving them that inch. Saying, "Oh, well, if you just compromise," and these therapists are so terribly informed. I can tell. I've never met them, but I can tell that they don't know what they're doing when parents talk to me about how they're proceeding because they are naively assuming that the child will be satisfied, right? So the child puts it forth like some sort of compromise, like a position that they can settle on, right? Well, if my parents will only call me this, or if they'll only do this for me, and then I'll be okay, right? And then the therapist naively believe that, collude with the child, argue that position to the parents. And I think these therapists really think that that that'll make the kids stop resenting the parent, be more open with them, start collaborating and working with therapy in a more productive and holistic manner, and that eventually they'll be able to get them to a better place. That I really think that's what a lot of these therapists think, and they're so wrong about that. Because if you've been studying this issue intensively for a while like I have, you see that the goalposts are constantly shifting with these kids. They might sincerely believe that they will be satisfied by their parents compromising on the name or pronoun issue. But their so-called euphoria in reaction to that is going to be short-lived, and then they're going to up the ante again. And every time a young person reinforces the belief through their actions, their words, their counseling relationship reinforces the belief that they have to be seen and treated a certain way in order to be themselves, in order to be okay. They're strengthening the neural pathways associated with gender obsession and digging themselves further into that hole. So I am so frustrated with my colleagues on this issue. I have this conversation every single week in my coaching work. Um, I tell parents, it sounds paranoid until you've seen what I've seen. Then you understand why I say that therapists are guilty until proven innocent on this issue. So, all of that is my little soapbox rant in reaction to the topic of healthcare. Because, yes, that is a healthcare decision, right? The decision to participate in social transition in any way, to affirm the identity, to use the name and pronoun, is endorsing it and is having an impact on what's happening with that developing child's brain.
It's a stepping stone off into the next thing on the conveyor belt you mentioned earlier, which is medicalization and hormone therapies and chemicals and surgeries and the I don't know if you've heard these statistics, but the desistance I heard from these social scientists who study this a lot. They said the desistance rate of people who once identify as transgender is over 85%. Okay, if it may, I don't know if those numbers are correct or not, but if it's anything close to that, we've got to be very careful pushing kids to make decisions that they may regret for the rest of their life. I mean, this is one thing where you can really do a lot of damage before you realize what's happened. And we're talking about kids here. This whole idea of autonomy has made us insane, right? We're going to make young people who don't have their prefrontal cortex fully developed, they're not 24 or 25 or older yet, we're going to cede autonomy and authority to them to direct the counselor and the parents as to what happens that may affect the rest of their life. In either context, this would be insane. If our kid came to us and said, "Hey, I feel like I'm a crocodile today," right? What would we do with that information? Would we just say, "Yeah, I have, whatever you want to be, you can be a crocodile"? And I'm not trying to minimize the issue, but what I am saying is this whole bandwagon effect is, peer pressure and bandwagon has not just affected kids and what they're experiencing. It's affected or infected. It's like, I don't want to call it the woke mind virus, but maybe I will. It's made people stupid. to actually put aside normal safeguards and commitments to truth that we would have in every other context in professional society. We've just kind of gone insane collectively together on this issue, and I think, thankfully, we're starting to wake up from our slumber.
Yes, and we don't know what the desistance rates really will be with this cohort because we've never run this experiment before. The desistance rates we know more about have to do with an older cohort of people who are mostly turned out to be gay and lesbian. And we're talking about, gender atypical behaviors and gender dysphoria in young children. Well, now we have a social contagion where we have girls who were very girly and feminine until last week. And then the perfect storm hit between her social influences, her online influences, her normal frustrations with things like menstruation, all these things hit. And then, unfortunately, the pansexual to non-binary to trans pipeline in middle school girls is still alive and well, as much as there is speculation and anecdotal reports, and I see them too, that it seems to be no longer trendy, or that, there's a younger generation that's had this propaganda shoved down their throats so much that they're growing up sick of it and rejecting it. As much as that's happening, there is still that pansexual to non-binary to trans pipeline in adolescent girls in the schools and a lot of other sources of indoctrination. We also see it at later ages with the males. That's anecdotally what I see is the males tend to be later ages, and that's also when Lisa Littman presented at GenSpect in Albuquerque in September, some preliminary research that's not published yet. That was what her data was showing as well. Also, if you go to dtrans.ai, I've had Peter James Stephen, the creator of dtrans.ai, on this podcast. We've talked about how the data from his Reddit forum scrape also matches up with sort of younger females, the older males, right? So we have like an increasing picture of who these kids are, what their demographics are, and those girly girls, the ones who are repressing their femininity to hide behind the shield of masculinity because of what that represents to them. Um, I mean, what are their desistance rates going to be? Like sky high, right? But we're medicalizing it, we're affirming it. So we've never run this experiment before where all of society is on board, where a temporary state is being taken to mean something else and medicalized. So it's just going to be a big crazy mess for many decades to come. I mean, I think probably the rest of my life, I'm about halfway through. About halfway through life, and I feel like this is gonna, I don't know, I'm gonna be in the retirement home, and hopefully I'll be respected. I'll be like, "Yeah, I was one of the first, I was one of the first calling BS on that," but, I mean, we're gonna have a lot of regretful, sterile 30 and 40 somethings with a lot of health problems. I say this as someone who has struggled with my health a little earlier in life than I was hoping to have had to do so. And I just really feel for where these kids are going to end up.
I would just one thing I would add to that, what we're starting to see in my former life as an attorney, I did medical malpractice cases, right? And so we're starting to see detransitioners win malpractice cases, and not only against doctors, but I think who did the surgeries and procedures. I think it's going to be against some of the counselors who pushed them in that direction too. So I think we
Yeah.
talk about being on the wrong side of history or the right side of history. We also could be talking about hurting people and being held accountable for hurting people. And so
Yeah.
I think we're going to see that conversation grow. And actually, the same firm that is litigating the Mirabelli case is suing Kaiser for Chloe Cole. So
So I did have Benjamin Ryan on this podcast to discuss the Varian v. Einhorn verdict as soon as that happened. And I've been in the gender critical scene long enough. I remember when we were all like, what about when there's finally a verdict? Like it was years of like, we need one of these cases to succeed. And then it happened, right? And it was very in the Einhorn. And it feels so significant to me as a therapist who's speaking out against this issue and who's completely pivoted my career to focus on this issue in a much different way than I ever imagined possible. Um, that the very first detransitioner lawsuit to succeed found the psychologist 70% liable for the harm. That is huge. And I mentioned it on that episode, and I'm going to mention it again here, that the psychologist in that case worked for the company that essentially, what's the word when a company buys out another company? Acquired? Yeah, acquired. Um, the company that acquired the company I used to work for. In other words, I worked for one little company over here that was regional. He worked for one little company over here that was regional. The same company bought out both of those nationwide, right? So I would have been colleagues with this guy. I mean, we're basically professional cousins. the guy, the guy who's found 70% liable. And of course, the company doesn't want the spotlight on them. Nobody knows that Lifestance Health is um, Einhorn's employer, but I'll say it because I don't mind. I don't mind saying that that there are individuals. I mean, the whole way that this was handled in the case, there must have been some agreements behind closed doors that they were going to keep the focus on the individual psychologist and not the environment that he worked in. But I think at some point we have to deal with the environment because as a therapist who worked in a group setting, probably quite similar to the group setting that he worked in, there is a standard of care established in that environment where if you don't um, have the proper expertise for a certain presenting problem, you'd go and talk to a colleague or you get more training or you bring it up at a clinical meeting with your colleagues and you say, hey, can I consult with you about this gender dysphoria case or whatever? Right. And gender dysphoria, by the way, was like never in her record even. Um, so as the heat gets turned toward therapists for their role in this, right? Everyone's going to want to pass the buck. Oh, I was just following orders. I was just doing what I was told. But as, people like Einhorn get found liable for the harm that they've done in, detransitioner cases or other forms of malpractice, at some point we have to look at what are company policies, what's being taught at trainings, um, like the culture of psychotherapy. And so, on that note, I know that you advise therapists, mostly in California, and some of that has to do with religious therapists who want to offer voluntary talk therapy for people with unwanted same-sex attraction. That's not something we're gonna get into here because I am Switzerland on that issue, but, I'm curious, because that's kind of the more extreme manifestation. I know a lot of therapists who, um, just wanna be able to speak more freely about gender identity. What can you say to the therapists in the audience, particularly the therapists in California or any other blue states that you might know of, um about their freedom of speech and their freedom to uh, adhere to their conscience and their sincerely held beliefs in counseling relationships with young people presenting with gender distress? What can you say to those therapists who are listening?
Yeah, so there's a case pending before the Supreme Court right now. It's a child's case out of Colorado, and um, I was asked to file an amicus brief in that case, but I was too busy to do it at the time. But a lot of the counselors and therapists I work with filed briefs in that case. And it's pretty clear that the US Supreme Court is going to uphold the right of people in talk therapy to not have compelled speech, right? And in this case, Charles happens to be a Christian, but her it's not just her religious liberty that's at stake. It's whether counseling, licensing bodies and state officials can coerce speech as far as talk therapy. And talk therapy is classic free speech, and we believe that the U.S. Supreme Court's going to affirm that principle. So whatever side you're on of the same-sex attraction issue or the transgender issue, what we advocate and what we think the Supreme Court's going to affirm is the right to speak as freely as possible without being constrained or coerced or pressured. And, jumping back to the malpractice issue, I think that one of the fallouts of this whole transgender agenda is that the adults in the room and the professionals in the room, by adults, I mean teachers, parents, therapists, surgeons, did not behave like adults. And they were not objective, and they didn't look at the truth, and they gave way too much autonomy to the child whose prefrontal cortex, as I said earlier, wasn't developed. And so the adults have failed kids, and we need to apologize for that, repent of that, and never do it again. So that's my soapbox for today.
That's a great soapbox. Well, where can people find you?
I have a website. It's nclplaw.org. It stands for National Center for Law and Policy, and law.org. And I do a little bit on Twitter and some on Facebook, but the main place to find us is probably on our website or check us out on Facebook. But I've been involved in the whole sexual identity movement probably for the last 25 years in various legal and public policy aspects. So I'm very familiar with it and very, very pleased that on this issue, we seem to be pushing, telling the truth and pushing back evil and winning. So I'm really encouraged right now.
Well, thank you so much, Dean Broyles, for all of your advocacy, all the work that you're doing to help our movement succeed, and for sharing your expertise with us on the podcast today. It's been a pleasure.
Thank you so much, Stephanie. Good to be with you.
Thank you for listening to You Must Be Some Kind of Therapist. If you enjoyed this episode, kindly take a moment to rate, review, share, or comment on it using your platform of choice. And of course, please remember, podcasts are not therapy, and I'm not your therapist. Special thanks to Joey Pecoraro for this awesome theme song, Half Awake, and to Pods by Nick for production. For help navigating the impact of the gender craze on your family, be sure to check out my program for parents, ROGD Repair. Any resource you heard mentioned on this show, plus how to get in touch with me, can all be found in the notes and links below. Rain or shine, I hope you will step outside to breathe the air today. In the words of Max Ehrmann, with all its sham, drudgery, and broken dreams, it is still a beautiful world.